on the issue of the governor that I had raised. Yes, there was no petition before the Election Commission on the 30th of June. That was filed only on the 19th of July. Uddhav Thackeray was the Chief Minister of the Shiv Sena. So in what capacity did the governor, give an audience to Eknath Shinde and administer the oath of office to him? How is that the discretion of the governor to do that? Which party was the governor, recognizing for the purposes of forming the government with the support of the BJP? That's the heart of the matter, and that's nothing to do with the power of the speaker now, This is an independent challenge, on the appointment of Eknath Shinde as Chief Minister by the governor, and the act of the governor is subject to judicial review. What it does, what paragraph 3, when paragraph 3 is deleted, the governor by his action recognizes paragraph 3. He recognizes the split. This is not a stage where the government is to be formed. This is a stage when an elected government is running. So your lordships for the first time will have to decide what are the discretionary powers of the governor in that context, and can his discretion be used to topple a government with respect to a set of people who say they are split from the Shiv Sena, when a Shiv Sena Chief Minister is already in place and the governor does not ask the Shiv Sena leader as to whether you are endorsing this or not. By not asking the Shiv Sena, he is recognizing a split. No, there is no discretion after an elected government is formed. The government then will fall on the floor of the house. Then the question of the discretion of the governor will come in. If there is a no confidence motion, government falls, then the question will come in as to who the governor will call. But the governor cannot by his act topple a government. The question is not that. When the governor was approached, by BJP as well as Eknath Shinde, and the governor told us to have a trust vote, on what basis did he ask us to do that? He obviously recognized the 39, otherwise he wouldn't have asked us for a trust vote. There was no occasion to. Because they continue to be in the Shiv Sena, that's their own case. That they did not, move away from the Shiv Sena. So if they did not move away from the Shiv Sena, which is their own case, on what basis did the governor say you have a trust vote? Unless he recognizes that the 39 members are rebels, they have split from the Shiv Sena, therefore they and BJP have a majority, therefore you go and show your majority in the house and have a trust vote. That is, logical, that's the only way to look at it. And the governor must act consistent with constitutional morality. What's the moral foundation of such an act? I've already said deletion of paragraph 3, I don't have to read. Of course, it's a principle of constitutional morality. Admittedly, the governor never called for a floor test, nor did he ever require the chief minister to establish his majority in the house. The governor's actions based on feuds and wrangles of a breakaway group, which is not recognized under the 10th schedule, cannot be constitutionally condescended. It's directly on point. Because the governor, by asking me to go for a floor test, having a trust vote, has condescended to recognize a breakaway group, expressly prohibited as the governor's action struck down in Navam Rebia. So we don't have to go into the issue whether the matter should be sent back to the speaker or not. If you decide this issue, the matter is, nothing else is required to be decided. So we challenge the trust vote, we challenge the action of the governor to swear him in as chief minister. If that goes, everything else goes. Then we don't have to go into the problematic issue of sending disqualifications back to the speaker. And ultimately, the facts are so crystal clear that they can't be the subject of yet another interpretation. They can't be, The Constitution doesn't give him that power. The 10th schedule, he is far away, far removed from him. Para 3 has been deleted. Breakaway groups can't be recognized by the, that way, Malas, every day a breakaway group will be recognized by the governor and governments will fall. I don't think, Malas, the Republic expected this. And our constitution, Malas, ever envisaged a situation that can happen in our constitutional democracy. The whole integrity of the political process comes to naught. Nabam says the 3 areas in which the governor has discretion, beyond that none. 371, Article 200, and Muller's forming a government at the initial stage after an election. There is no discretion with the governor. He acts otherwise on the aid and advice of the Council of Ministers. That's settled law. And of course, 356, Muller's, sending a report to the central government. That's not something on the aid and advice because, so 356, 200 and 371. These are the 3 areas.
Mr. Sibal, once a person incurs a disqualification under the 10th schedule, then the consequence under Article 193, bracket 3, is that his seat shall thereupon become vacant.
Yes.
Because 190 in terms, 193 in terms refers to 191(2).
Yes.
Which refers to the 10th schedule.
That's correct.
So the seat shall thereupon become vacant. So suppose a group of MLAs, forget this case, suppose a group of MLAs incurs a disqualification by being a split, which otherwise is not recognized by the 10th schedule.
Correct.
So the strength of the house therefore falls by the extent of the disqualification.
Absolutely.
In which case the majority required for a motion of confidence would also be altered. So suppose in a house of 200 members, 20 have become disqualified.
Right.
Then it would be 90 instead of 100 for the vote of confidence.
Correct.
So would the governor in such a case be justified in saying that, well, I still want a vote of confidence, because assuming that these people now are disqualified, I still want to test the legitimacy of the government after excluding these persons. Can he do that?
If the arithmetic is so stacked, Malas, he can, but nothing more than that.
Right.
The arithmetic is so stacked, he can.
Because the consequence is that those people have to be excluded from the house.
I agree.
The number comes down, and then he can say, well, I want...
Correct. So therefore, Malas, the arithmetic...
minus these people who are disqualified to establish that they can...
No dispute on that proposition, but that the arithmetic will decide.
That the arithmetic will decide.
Here that question doesn't arise. Well, your lordship is right, but that the arithmetic will decide. There is no discretion there. He'll call the chief minister, he says, these people are excluded, this is the arithmetic, this is what the numbers are, prove your majority.
No, but then look at it this way for a moment. I mean, we are not at all on the facts here, but just to test a constitutional position, which is that, say or we can, just for the sake of clarity, the Shiv Sena has 56.
Yes, ma'am.
Or had 56 when the government was formed.
55, right? I thought, Malas.
Sorry, 55. 55. Now, disqualification notices were issued to 22 plus 16, 38.
That's right.
So, for a moment, for the argument, we proceed with your hypothesis that this is a split and therefore they are disqualified. Right? So, then the Shiv Sena is left with 17.
Yes.
If these people are to be disqualified.
Yes.
So, it comes down to then 17 plus NCP has how many? 44 or how much?
54.
Is 53.
53 plus 17, 70.
Yeah, I just see.
And Congress has 44, right?
Yes, 44. BJP is 106. Even then, it will be fine.
Right. So, in such a situation, would the governor be justified in saying that, look, assuming that these people have incurred a disqualification, I still call for a trust vote, because the impact of these 39, at that stage, he is not deciding the disqualification. At that stage, the governor says, well, according to me, as a constitutional head, it appears that these people they have split. I'm not deciding that they have split, because that's the discretion of the speaker. Can the governor now not say in a given case that, look, these facts now stare at me. I postulate that these people have incurred a disqualification. I don't treat these as members of the house at all. But therefore, because these people stand excluded, and the strength of the ruling of the government then falls down to the extent of the extent of the split. I want a trust vote.
Well, let me analyze that in two ways. Number one, you can't then administer an oath of office to one of those who is
Yeah,
disqualified.
you're right. Absolutely correct. Your line of thinking and line of argument on this is
Okay, now let's forget that.
that we'll keep aside.
We'll
Now,
keep
let's
aside. Now, Maharaj,
the power
then
of the
somebody should tell the governor that constitutionally what happens, Maharaj, from my
Yeah.
little experience, the numbers, if stacked against the government, will go to the governor and say that the leader of the house has lost the confidence of the house.
Right.
Then he will analyze that and call. But governor will not do this. That's not his job. There's a sitting chief minister. It's an elected government.
You're right. At that stage, the governor is not really calling upon someone else to form government. But what he can certainly do is that, well, according to me, you have a ruling party with, say, which is supported in a coalition with, say, 60 members. Out of the 60, 40, which is a split, the governor says that, well, this is a split, and this is a split which is not recognized now by the 10th schedule. The speaker is going to take his own time to decide on the disqualification. But as the constitutional head of state, I do believe that with these 40, having, contrary to the constitution, moved away, at least as a head of the state, I require a trust vote on the floor of the Legislative Assembly. That I don't believe the governor would be wrong in calling for a
Well,
trust.
I will say it is wrong, Mala, then I'll constitutionally provide an answer.
Why would that
The
be?
moment a governor does that, Mala, take Maharashtra, there are any number of parties apart from Shiv Sena, apart from NCP, apart from Congress, there are so many small parties. Now, those small parties at the moment supporting whoever is in power. The moment the governor does that, the buying and selling will start. In fact, the governor will be inviting by his unilateral act of saying, prove your majority. There's no question of proving majority. He is the chief minister.